Today's community of practice talk is really just about how copyright and generative AI are intersecting and what other legal issues might be coming up or are being discussed, and talk about there are several lawsuits that are currently underway, specifically about fair use and generative AI. So what the lawsuits are alleging is that generative AI training data and the way they were trained infringes on copyright. Some of those cases are Getty Images versus Stability AI Incorporated, and there's also another one which is a combined visual artists lawsuit against Stability AI, Midjourney, and DeviantArt. There are also more cases, and each of those lawsuits pose a slightly different question to the courts about copyright infringement and how copyrighted works are used in AI models. Now, many of the publicly available generative AI text and image technologies are based on large language models created to generate believable human text. Now, without being an expert on how large language models work, the description of their makeup is usually something like a large amount of data, including copyright protected data and images, is copied into a database that the generative AI model is then trained on. Now, the model itself does not hold copies of the data, and this is important. Instead, it's learned from the data what answers, what text, what images are expected when it is given any certain type of prompt. So its output then is not a copy of the training data, mostly, but it's supposed to be a new creation that has been informed by previous work. So this method of operation is key to many of the arguments about what generative AI tools are doing should be considered fair use. Now, fair use can only be officially determined in a court, and court cases can take many, many years before any official guidance can be gleaned from the determinations. An example of this, Authors Guild versus Google. It was a recent case in terms of copyright law where authors sued Google for the mass copying of copyrighted works that created the Google Books search capacity, right? Where you can put in a keyword and it will look through the text of several books and tell you the snippet and what pages those words were found on. That case lasted from 2005 to 2015, so 10 years. Now, Google's use of the material in the end was determined to be a fair use by the courts, and this is also a case that the makers of generative AI technologies and people discussing the fair use in training LLMs are pointing to, because the idea of including copyrighted material in a database that's not actually directly accessible to the user or the public was a large part of that argument. So in a similar way, generative AI models are being trained on a database of material. Yes, it includes copyrighted material, but it's not accessible to the end user at all. It's being used for a different purpose, and the end user is interacting with something different. Now, some of those copyright infringement cases against generative AI tools also point out that many tools are being asked to, and they do, create work in the style of a named artist. Now, while the argument against that is that styles, like ideas, like facts, aren't protected by copyright, there is recent case history that highlighted commercial competition as one of the deciding factors that a use might not be fair. And that's the Supreme Court case of Andy Warhol Foundation for the Visual Arts versus Goldsmith. And in that case, the Supreme Court ruled in favor of Goldsmith, who was the photographer of the Prince portrait that Andy Warhol then used in his series of posters about Prince. Now, it was found that when Andy Warhol Foundation was licensing his poster series, it was impacting the photographer's ability to license her own original photo, and it damaged her commercial options. So while the case didn't specifically comment on whether Andy Warhol's use of the photo to create the poster was a fair use, it did say that through licensing that commercially, that act was an infringement of Goldsmith's original copyright. So this decision has been brought up by artists, and those arguing in support of artists that what generative AI tools are doing should be considered an infringement because it's creating this commercial competition. There's still the argument that styles are not protected. So while we're waiting for the courts to provide us with solid decisions, I would say this argument poses an interesting and concerning question that should be on people's minds regardless of what the answer the courts give us will be, is that should generative AI be allowed to replace our artists and photographers and writers? And also, how will artists and writers work in a world of generative AI? And those questions still need to be answered. So these are the two main competing arguments in the fair use cases that are at issue right now. And like I said, it's going to take a long while for that to get a definitive answer. Now, beyond that, using copyrighted information to train a massive large learning model is just one way that copyrighted materials are being used with generative AI. So it's now possible to feed an existing model curated text, data, and images in order to create and train custom chat interfaces to serve various needs. So if the curated materials fed to the existing model are protected by copyright, this is a new and distinct use of copyrighted content. And if that use is perpetrated with a fair use argument, it must be looked at separately whether or not training the LLM could be a fair use. So in a fair use argument, all four factors must be balanced together. We know that while an educational and instructional use might be considered fair under factor one, the purpose and character of the use, how that use weighs with the other factors will come into play in deciding the strength of the argument overall. Remember some of the points in why Google Books case was a fair use, that all of the copies of the copyrighted works could not actually be accessed by the public. So while that is similar in how LLMs are trained, for the most part, that might not be the case in inputting copyrighted content to train a custom bot. So access of the end user to the full original content through the bot will be part of a fair use argument when working with generative AI in this way. So not only access of the end user, but also how many end users have access to the custom bot, all of that gets wrapped up into a fair use argument. Copyrighted material may also be fed into generative AI by the end user. Say a user loads a copyrighted document into an AI chatbot and asks for the bot to create study questions from the document. Now, whether that document is now available to other users and how those study questions are used will be important to figuring out if this use as well could be considered a fair use. So whether or not a generative AI tool's use of copyrighted content to train can be found fair use, the text and images created by generative AI may still infringe on the copyright of an existing work as well. So even if generative AI is not giving a direct copy as an output, it could be creating a derivative, and derivatives are one of those exclusive rights under copyright law only allowed to the author or the rights holders. So if the work created by generative AI can be considered a derivative of a copyright protected work, then it could be an infringement. And fictional characters are a really great example of how generative AI tool can be prompted to create a derivative and a possible infringement. And that it's illustrated here as the Snoopy problem, which was coined by Matt Sag, who's done a lot of work on this. Fictional characters, when they're well delineated, that is when they are more than just a stock character or a type of person, can seem to receive copyright protection separate from the work or works where they were originally conceived. So Snoopy is a good example of this. Snoopy is more than a cartoon beagle. He's been developed over time with a certain look and set of characteristics that anyone would recognize. So if you ask generative AI to draw you a picture of Snoopy playing a piano, you're going to get a picture of Snoopy, a copyright protected character playing a piano. There's no other Snoopy, so the generative AI is likely to give you something that looks pretty close to what you'd find created with the rest of the Peanuts characters. Now, depending on how the picture is used, it could be an infringement of copyright law. Now, that example from the last slide of an end user feeding a copyrighted document into a chatbot, a document like a textbook chapter, and asking for study questions or maybe a study guide, that guide could also be considered a derivative and an infringement depending on the other factors in the fair use argument. So to sum up, there are many places in the creation, training, and use of generative AI technologies where copyrighted material is used and could be infringed on. Now, the court cases currently underway are primarily concerned with just one area of use right now, and that is the development of the large language models and their training. So it's important for us to keep in mind that subsequent uses of copyrighted material, that of training custom chatbots or loading material directly into a bot as part of a prompt, are considered separately from whatever the courts decide about LLM model training. So each individual use of copyrighted content would need to be looked at separately for its own fair use argument. Now, it's also important for any user of generative AI technology to realize that the outputs of AI could be infringing, even if there's no copyrighted material that's being loaded along with the prompt. Just because Bing made the image of Snoopy on request does not mean that the image is now free for me, who is the user, to use in any way I want without thinking through its copyright implications. Now, I've been saying infringing a lot, and I want to make clear that a fair use argument is still possible at any step of the process, at any of these points where copyrighted material might be used or created. Fair use is not an infringement, but we do need to look at each point in time and each point in the process, each individual use separately, and just think through that use and to figure out the fair use argument for each type of use. So, of course, no consideration or discussion of fair use in the use of copyrighted materials would be complete if we didn't look at terms and conditions. Now, every interaction with material online could be governed by terms and conditions, and how much power those terms and conditions have over the end user is linked to whether the user was alerted to those terms and agreed to them, which happens whenever we make a user account. Now, the terms and conditions of generative AI platforms could place restrictions on what end users can do with the outputs given to them based on their prompts. Similarly, the terms and conditions of databases could place restrictions on whether the content found in those databases can be used with generative AI. So this is happening in some of our library contracts right now, as we learned from Sarah Swigert last meeting. Depending on how those terms and conditions are written, a use might be restricted even if it has a strong fair use argument because of how access might be restricted. Now, all that said, copyright suits are not the only legal questions out there right now that could change how generative AI works in the future. And those are really what's up in the air right now, right? So there are a lot of court cases, there is pending legislation, and all of that could require the makers of generative AI to make changes and change the technology, which would change how we use it. Now, SAG-AFTRA, the actors union, took issue with reported proposals by production companies that say a background actor could be scanned and replicated, so paid for a day, and then their likeness used in perpetuity with no further remuneration. So outside of employment contracts, which might actually protect individuals negotiating their rights if they have power to negotiate, like through a union, like SAG-AFTRA, there are some few state laws in place that individuals might be able to use to protect themselves and their likeness from being commercially exploited. Some U.S. states recognize personality rights by statute. Many of these laws will expire with death or last for a limited time after death, and many are only concerned with commercial uses. So in addition to that, there are no federal laws regarding the matter. The laws do vary greatly by state. So still unanswered are questions on what a person can do if their likeness is used for non-commercial purposes. Inevitably, questions on personality rights have rolled into discussions on deepfakes, which is an area that's also lacking on regulation and legislation so far. As with the story of the Pope in a puffer jacket, pictured here, it was created by Pablo Javier. Photos created just for fun could find a viral life of their own that causes more harm than good. So in an article with BuzzFeed, Javier said he had instant regrets once the photos went viral. He was just playing around, right? He saw posts criticizing the Catholic Church for unnecessary spending based on the Pope's wardrobe and citing his AI creations, his photos, as evidence of this unnecessary spending. So I'm sure all those arguments were disproved in the end, but in the moment, it caused a lot of people more grief than Javier ever intended. He was just playing around with the generative AI tool he had. Now, current legislation to prevent deepfakes could also affect free expression and curtail the possibilities of AI. The No Artificial Intelligent Fake Replicas and Unauthorized Duplications Act, or the No AI Fraud Act, in the House would create a federal intellectual property right that would outlive the individual whose digital likeness and voice is protected. So intellectual property right, kind of like copyright, exists long after death. So anyone who publishes, performs, distributes, transmits, or otherwise makes available to the public a digital voice replica, a digital depiction, or a personalized cloning service with the knowledge it was not authorized by the rights holder would be in violation of that new intellectual property law. There is another piece of legislation in the Senate called the Nurture Originals, Foster Art, and Keep Entertainment Safe Act, or No Fakes Act. It also creates liability for users of digital replicas. No fakes, however, it does carve out space for documentaries, docudramas, and the uses of digital replicas for criticism, scholarship, and parody. Some of these uses are specifically mentioned in fair use as well, so they might sound familiar. But unlike fair use, which is very flexible, the exceptions in no fakes would be a very prescriptive list and wouldn't necessarily account for legitimate future uses we've not yet imagined that were not included in that list. Now, just like the no fakes and no frauds, or no AI frauds, the users of generative AI tools are responsible for their future use of the generated content. So generative AI tools like ChatGPT are programmed to generate coherent language or pictures to a user prompt, not truth, not facts. To our last example, the creators of deepfakes are responsible as well if they promote that the material is truth. So using generative AI in research, reporting and advising should be done with human fact-checking, validity checks, and also with transparency. Now, the pending legislations like the No AI Fraud and No AI Fakes or No Fakes could create situations where the generative AI tools themselves will be programmatically limited in their use to reduce the possibility of deepfakes. Some experts have proposed that encoding limits into generative AI tools could also be a way to limit derivative outputs, like the Snoopy problem. Now, others would disagree, and they argue that legitimate, fair, and innovative uses may be curtailed by programming restrictions. So in their argument, just as with other tools like a VCR or the computer, the end user should continue to be responsible for the material they have generative AI create for them. So while the end user might be liable, they're not necessarily the author of the content. Some creators using generative AI to create comic books and photographs have claimed authorship of and copyright over the works, but the prevailing argument is that generative AI is creating the work, not the author of the prompt. So where the user has to take responsibility that's akin to the responsibility an author might take, they don't necessarily get to claim authorship. So can generative AI be an author? And what is an author according to copyright law? Well, I'll say previous case law also gives us some hints here. This case, Naruto versus David Slater, or the monkey selfie case, the judge's decision was that copyright law was not written for animals or any other human, and so that they could not be authors and could not own and control copyright. So this question of authorship hinging on being human or a person also comes up in debates on whether using material created by generative AI like ChatGPT should be considered plagiarism. So the definition of plagiarism often includes mention of someone else's or another individual's work being used and not credited. In this line of thinking, generative AI is not a someone, but if instead we think of plagiarism not as the theft of someone else's credit, but simply that of intentional or careless lack of acknowledging one's sources, of passing off work that's not your own, then the term might still apply. But this indicates that generative AI might even be changing the definition of some of the words we use all the time, words like plagiarism. Now, similar to the judge's decision in Naruto versus Slater, the U.S. Copyright Office has issued guidance that explains the requirement of human authorship for copyright protection. So to be an author of copyrighted work, according to this guideline, the creator must be human. If users of generative AI tools are creating something that they eventually want to have registered with the U.S. Copyright Office as original, they will have to fully separate and describe which components of their final product are their own creative work and which were created by AI. Now, that copyright law doesn't cover material generated by AI could be seen as a balancing mechanism to the potential harms that could come to artists who now have to compete with generative AI for work. So back to that question of how artists are going to interact in a world with generative AI possibly as competition. So much of the money made on a new book publication, for example, a movie, and all the various memorabilia associated with it is due to the copyright owner's ability to control how the work is copied and sold. Now, consider a manga publisher that has AI generate a new manga for it in a matter of a day or less, so much less time than an artist, probably a lot cheaper than if they were paying an artist. Well, in the end, how lucrative would that AI-generated content be if the publisher could not leverage the intellectual property protections and control how the material is used after its release? Human authors, on the other hand, still have full and immediate copyright protection for their work and can control how the material is used and leveraged in the marketplace. Now, while the guideline from the U.S. Copyright Office appears very final, it is facing several challenges. There are currently several governments and agencies that are discussing how copyright will or will not apply to images created by generative AI, perhaps with the aim of providing some type of protection. Now, copyright law in the UK, for example, may already cover images created by generative AI, and France has issued draft legislation on how generative AI material will be treated by copyright law. These examples around the globe give an indication of how other countries are addressing generative AI, which could eventually have an effect on trade agreements with the US and then affect US law. Now, the copyright case in China, it's very, very recent, was just decided in favor of a human prompter having copyright over AI-generated art that resulted from his prompt. So completely in opposition with what the US Copyright Office has issued as guidance for the US. In China, there was a human prompter was given authorship and protection over this work. Now, the case in China notably related the use of AI to the use of a camera. So this echoes several counter arguments for allowing generative AI work to be copyrighted. And in the US, the argument specifically points to a case involving the photography of Napoleon Cerrone in 1889. So this case, the Burrow-Giles Lithographic Company versus Cerrone, affirmed that copyright was extended to photographs. Now, up until that time, many people saw photographs as just capturing the natural world, of relating facts frozen in time. The natural world and facts were not protected by copyright. They are not protected by copyright. Now, photographs were also considered to be the result of a mere mechanical process, and this is an argument that Burrow-Giles Lithographic Co. put forward in the case. Now, the judge in that case decided that the camera was just a tool that the artist employed to capture his original creative vision. So if generative AI, like the camera, is a mechanical process employed by the prompter as an artist, then should the outputs have copyright protection? Now, what I want to plant in your head here is that the judge's reasoning in the case in China had to do with the multiple iterations of prompts that narrowed the randomness of generative AI until the user got exactly what he wanted. Randomness seems to be the most important aspect differentiating generative AI outputs as creations of the technology rather than as creations of the user of the technology. Now, even if we argue that some generative AI outputs should be protected and some not, how would we then tell the difference between what is protected and what is not? And as generative AI creates massive amounts of material that looks like it could have been created by humans, how are we telling now the difference between what is protected and what is not? Now, the U.S. Copyright Office's requirement of authors to clearly delineate which content they created separate from what AI created puts the onus of communicating the origins of that content on the user. Scholarly publishers were also quick to issue similar guidance, first on whether or not articles partially written by generative AI would be accepted at all, and if so, how that generative AI content should be cited or otherwise delineated from the original work of the author. Now, different publishers have different requirements, from restricting the use of generative AI to just copy editing or to making no definitive restrictions other than a requirement for full disclosure. Commonly, publishers do not accept generative AI tools being listed as a co-author, regardless of whether or not they restrict the use. They say that generative AI is not an author. Authorship and scholarly publication carries with it the responsibility of accuracy and validity, things for which generative AI has been shown to be unreliable, and it is a responsibility AI cannot take on. Now, publisher policies also echo instructions that sometimes show up in university policies, mainly that generative AI tools are not currently the place for confidential, private, or sensitive processes. As technology continues to develop, there might be more protective generative AI tools out there. However, the use of generative AI tools should always include considerations of privacy and perhaps a trip through the platform's terms and conditions to see how they use material that is loaded into the platform. Now, this quote here pertains specifically to using generative AI to help with the peer review process. The confidentiality required in peer review rules out generative AI as it is right now as a method of speeding the process up. So, in conclusion, in my daily work, I'm often helping researchers and faculty figure out what they can do with material they find online. That's where the questions start. So I'm anticipating a future proliferation of authorless material online. Perhaps that material has notes on it that it was created by generative AI, and perhaps it doesn't. Some of the tools I used to use to help track down those JPEGs stored in faculty files or in some old PowerPoint, like Google Reverse Image Search or TinEye, they don't help so much in AI generated materials, and some of the AI tools designed to identify AI generated content are also not completely reliable. I would say, AI generated content could be a boon for adding visuals to a presentation without worrying about your fair use arguments or on obtaining permissions. But knowing for sure what is generative AI created and what is not now relies on people providing transparent citation to the generative AI tool. I think this is a great place where libraries can serve as examples. So embracing the generative AI technology while adopting and promoting the expectations for transparency that are emerging out of higher education, out of the Copyright Office, scholarly publishers, and other government offices. Libraries are also uniquely positioned to help people interact with generative AI and the information it creates. So recent discussions of AI literacy include competencies that help people evaluate, communicate, and use AI. Now, copyright or the lack of it, policy and industry expectations are all laced through this new literacy. Further developing and promoting these literacies can help us move forward in research and scholarship and the evaluation of trustworthy online content, and help us also instruct our users and the public on those same things.